Hi, I'm Veronica Aces, Client Relations Liaison at William Blackstone Internacional, an international advisory focused on diplomatic frameworks, international protocol systems, and cross border institutional structures. The following analysis is academic in nature, intended for informational purposes only, and should not be constructed as legal advice. Today's topic is diplomatic passports versus official passports. What's the difference? Diplomatic, official, and service passports are often described online as privileged passports. In law and protocol, they are primarily administrative identifiers issued by a sending state. Privileges like immunity depend on whether the receiving state has recognized the traveler in an accredited status under the Vienna Convention framework, not on the passport booklet alone. What is a diplomatic passport? A diplomatic passport is a government-issued passport intended for travel connected to diplomatic representation, or diplomatic duties. Many countries issue it to accredited diplomats posted abroad and to certain officials traveling on diplomatic assignments. Some also issue it to people granted diplomatic or consular titles for an official role and, depending on policy, to eligible family members. What it signals is the sending state's intent. The traveler is on diplomatic business. What it does not automatically create is immunity. U.S. guidance for special issuance passports states directly that such passports do not provide diplomatic immunity, do not exempt the bearer from foreign laws, and do not provide a shield from arrest. Outside a resident posting, a diplomatic passport can exist without any mission accreditation in the destination state. In that scenario, the passport remains a valid travel document, but legal privileges arise only if the receiving state recognizes the person's status for that visit and purpose. What is an official or service passport? An official passport is generally issued for government travel that is official but not necessarily diplomatic, often for civil servants, technical officials, administrative staff, and delegation members. The label service passport is used in some systems for specific categories of official travelers. One concrete example is U.S. law. It distinguishes official passports for authorized official duties abroad, including specified categories from service passports issued in exceptional circumstances to certain contractors when needed for contractual duties abroad. Governments also caution that official does not mean advantaged. Canada states an official passport is not designed to give any advantages to the bearer, and Australia states its diplomatic and official passports do not award special rights or privileges, with any special treatment left to other countries' discretion. Legal basis and accreditation under the Vienna Convention. The Vienna Convention on Diplomatic Relations explains why privileges exist, not to benefit individuals, but to ensure the efficient performance of diplomatic missions representing states. Protections attached to recognized roles. The Convention defines a diplomatic agent as the head of mission or a member of the diplomatic staff. For heads of mission, the sending state must obtain agreement from the receiving state. The receiving state's foreign ministry must be notified of mission appointments, arrivals, departures, and termination of functions, and also of family arrivals and departures. Privileges begin when the person enters the receiving state to take up the post, or, if already present, when the appointment is notified. The convention also explains how privileges end. They normally cease when the person leaves the country or after a reasonable period to do so, but immunity continues for acts performed in the exercise of official functions. Immunity is defined by category. Diplomatic agents have immunity from criminal jurisdiction and broad immunity from civil and administrative jurisdiction, but with listed exceptions. Waiver is possible but must be express and is made by the sending state. Not every mission member has the same scope. Administrative and technical staff have a narrower civil and administrative immunity. It does not extend to acts outside the course of their duties. Nationals or permanent residents of the receiving state generally have only official acts immunity, unless additional privileges are granted. Finally, privileges are not a license to disregard the host state. The Vienna Convention states that persons enjoying privileges and immunities have a duty to respect the laws and regulations of the receiving state and not to interfere in its internal affairs. This status-based approach is reflected in UK guidance. It is the host nation's accreditation that gives the holder diplomatic or official status in that country, not the passport itself. Common misconceptions. A large share of online confusion comes from mixing up three systems: passport issuance sending state, entry and visa controlled destination state, and diplomatic privilege status recognized under international law and domestic implementation. Visas. A diplomatic or official passport does not guarantee visa-free entry. Visa requirements are set by the destination state and can vary by nationality, travel purpose, and bilateral arrangements. Canada advises allowing time for foreign visa processing when required. And New Zealand immigration instructions state that holders of diplomatic or official passports traveling for tourism or private business must apply for a visa if not from a visa waiver country. Immunity. A diplomatic passport is not diplomatic immunity. Immunity depends on accredited status and category, and Article 31 contains explicit exceptions in civil and administrative matters. Waiver must be express. U.S. guidance states, a special issuance passport does not provide diplomatic immunity and does not provide a shield from arrest. Customs. Even for accredited diplomats, customs privileges are structured. Article 36 provides exemptions for mission and personal use imports, but allows baggage inspection where there are serious grounds to suspect prohibited or non-exempt items. An inspection must occur in the diplomat's presence. U.S. guidance also warns that special issuance passports do not exempt the bearer from customs and immigration laws. Family members. Family privileges are conditional. Article 37 covers family members forming part of the household and requires that they not be nationals of the receiving state. Article 10 requires notification of family arrivals and departures. Passport issuance to family members varies by sending state, and privileges depend on host state recognition and registration. Variations across national systems. Passport categories are domestic administrative choices. The Vienna Convention governs status and privileges, but it does not dictate who must receive which passport type or how passports must look and be labeled. As a result, passport practices differ across states even though the underlying treaty logic for privileges is widely shared. Non-exhaustive examples. The United States defines diplomatic, official, and service passports in regulation and publishes public guidance emphasizing that special issuance passports do not provide immunity. Canada distinguishes special and diplomatic passports and states official passports are not designed to provide advantages. The United Kingdom ties diplomatic and official passports to accreditation categories and states accreditation, not the passport itself, gives diplomatic or official status in the host country. Australia states its diplomatic and official passports do not award special rights or privileges. The analytic takeaway is that passport categories are signals. The legal question is always, what status has the receiving state actually recognized, and what privileges attach to that recognized category? Practical implications for travelers and officials. For travelers, treat these passports as role-specific. Use them only as authorized, and plan for visas and normal border processes unless you have confirmed destination-specific arrangements. Government guidance also commonly limits personal use and may require returning the passport after the qualifying role ends. Also, some national systems require you to maintain a standard passport for personal travel even while holding a diplomatic or official passport for work travel. UK guidance, for example, explains that customers must hold a standard passport and use it for personal travel. For institutions, the practical focus is protocol readiness. Ensure mission travel is supported by appointment and notification processes so host authorities can verify status quickly when questions arise. Recommended verification steps for authorities and hosts. For host state authorities, the reliable method is not passport guessing but status verification. Privileges attach to defined categories and begin upon notification or entry to take a post. Verify through the Foreign Ministry of Protocol Registry, confirm the person's accreditation category, and use host-issued credentials where available. New Zealand provides a concrete model. Protocol issues official identity cards based on notification forms. The card represents official recognition of status under the Vienna Conventions and carries a brief statement of immunity level. Where immunity questions arise, remember that waiver is a sending state decision and must be expressed. A passport cover should never be treated as final proof of immunity or its absence. Final thoughts. Diplomatic and official or service passports are legitimate government documents, but they do not create diplomatic privilege by themselves. The decisive factor is accredited status recognized by the receiving state and the specific privileges attached to that category under international law and local practice. If you would like to explore diplomacy further and take a first step into understanding how international diplomatic systems function in practice, initiate a private advisor inquiry at Blackstone.com.